Noel McLain appearing on behalf of the petitioner.
And this is Andrea Poplawski appearing on behalf of Mr. Brown. Mr. Brown is also present via Zoom.
Perfect. Day guardian ad litem also present.
So, Ms. Day, do you want to, I guess, kick us off?
Yes, Your Honor, thank you. And just so that you know, I did provide that letter as soon as I received it, and I dropped a courtesy copy off for you yesterday, and I'm not sure why it didn't make it to you, but we might need to look at that, but I'm glad you had a chance to read it. I did have a chance to talk with Charlotte Rosen and share some of the information that I had. And I do think that we are in a place now to begin that process of starting those transitional visits. I think that her recommendation to have 2 or 3 visits with Ms. Anderson, which is Lauren's regular counselor that she sees on a regular basis, 2 or 3 sessions to occur over the course of the next couple of weeks, and then to begin the visitation supervised therapeutically at Charlotte Rosen's office and start that process. I think that absent that, there's no other good way to get off of where we are now. There is no ongoing investigation at this time. There's no plans for a second CJAC interview. I agree that the allegations that are made are very concerning, and I don't doubt that they are not without grave concern. I know for mother and certainly for everybody involved in this case, but by the same token, we are in a position where we have to move forward in some manner. Father is adamant that he has not committed these acts or done anything that was even close to these acts. I think there's understandably his frustration in not having contact. By all accounts, and in Ms. Rosen's letter, the relationship between Dad and Lauren was healthy and strong and very bonded prior to this. And I think that the only way that we can move forward is to start to move forward slowly, safely, and protectively. And if issues arise, Ms. Rosen is there to help and to inform the court and myself, and steps can be taken if necessary.
May I ask Ms. Day a question?
Yes.
Ms. Day, last time we were here, you had also outlined a request, at least at that time, that there be no further contact or visitation until Mr. Brown had completed a psychosexual evaluation, because at least from what you had indicated, you don't know where the truth lies, and that would provide you additional information as to whether or not he was being truthful in his representations. Are you still making the recommendation that he participate in that psychosexual evaluation?
I think that's something I will potentially include in my report when I write my report, but the court had already ruled on that, so I didn't feel like I was appropriate to bring that forward again today. That was my request last time we were here, trying to find a solution to where we are. And the recommendation was to do this evaluation for the family assessment. I think that was an appropriate one. So I think that we're in a situation now to move forward with that. I will continue my investigation and try to observe those visits and then write a report and see if that's appropriate to continue with that concern and raise that then.
And I guess my only input relative to that is that I understood that the court was reserving that for further determination and argument today, and also to discuss costs. Let me go back to my notes.
And Your Honor, my understanding was that the court was not going to rule on that the court wanted to have this matter set over to a reunification evaluator to make a determination how we should go forward. Also with the ability for that individual to suggest if they felt that prior to going forward, they needed information from a psychosexual evaluation. And there's nothing at all indicating from Ms. Rosen that would be appropriate. I think, as the guardian ad litem has stated, we're trying to figure out how do we move forward. The evaluator has already spoken and has given us a very, very detailed, a very cautious, a very meticulous roadmap on how to do that. I think that makes the most sense for us at this time. Everyone has agreed that previously Dad has had a great relationship with the child, a bond with this child. Mom even told the evaluator that even though in her declarations to this court, she said something different. And we just really need to move forward on this. CPS is closed. There's no more CJAC. evaluations, the police investigation there's no intent to move forward. I think it needs to just stay as is for a statute of limitations issue. The guardian ad litem probably speak more about that, but I know she has confirmed with the investigator that they are taking no action on this. My client did the polygraph test, which proved he was truthful.
Again, I would object as to any discussion about a polygraph. That's not properly before the court. Counsel is well aware of the case law that I've already outlined, and that's not definitive of controverted facts that are before the court.
I think the guardian ad litem has known about this, and that's part of her investigation and part of information that would provide the ability for us to move forward. I think that's where we need to go at this point. So we would be asking that the court not order that let's just start moving towards getting this relationship back on track with all of the appropriate safeguards in place.
So,
and I'll just note, and this I probably will take probably speaking for Ms. McLain a little bit on this, but my notes in the minutes indicate that the restraining order, parenting plan, and request for psychosexual evaluations were set over to today's date for additional consideration. So I think it's still on the table. Arguably, I know that, well, I'm not going to speak for Ms. McLain any further, but I don't know if that's still a request. And I guess I would ask a follow-up of Ms. Day if it sounds to me based on Ms. Rosen's letter that even without that, they're willing to move forward at this point, and with essentially the plan that they've outlined with the counseling visits and then supervised visits and continued counseling. Is that fair?
That is fair. And that was my understanding. When I discussed with Ms. Rosen that I had made the request for a psychosexual and my reasoning for that, and I apologize, I understood that was not happening. So if the court wishes to make that decision, then I think that would be great. I don't think that that's an inappropriate request given the allegations that we have here in this case. Ms. Rosen didn't feel like she could speak to that specifically based on the evaluations that she had done already and the status of things, because she'd only met with the parents. She hadn't observed any visitation or contact. So she wasn't going to give input on that specifically, but based on the information, this was her recommendation for moving forward.
Okay. Okay. Ms. McLain, any additional questions for Ms. Day?
So I guess last time we were here, my understanding of Ms. Day's recommendation was that there should be no contact, that they were still that the child was still completing the sexual assault therapy with Ms. Anderson, that there is a future CJAC sometime anticipated to take place, that the criminal case with KPD is, while it's inactive, it is still on hold. Statute of limitations runs years after this child turns 18. So that's not, that's sort of a red herring. And then the request for the psychosex evaluation, again, when we have facts that have come before the court coupled with the sexually charged behavior by the child that has been observed, and the two different disclosures by this child to, actually, I think there's been 3 disclosures to 2 different counselors, that in and of itself warrants us having a further evaluation of Mr. Brown to hopefully provide some further feedback to this court on what's going to be in the best interest of this child. I think, obviously, speaking on behalf of my client, the concern is placing a 6-year-old back in, albeit a therapeutic supervised visitation location, but with a father who is accused of having sexually abused this child before the father addresses those underlying issues. It just smacks of putting the cart before the horse. We have a potential perpetrator, an alleged perpetrator, who has done nothing as far as any type of services to correct that behavior. And so, I mean, if we were looking at somebody who is addicted to drugs, we would require and mandate that there be evidence that they were no longer under the influence before they started participating in those supervised visits with the child. Similar here, is that
asked if there was questions for the guardian ad litem. If we're making argument, I believe it was my client's motion, and the motion was just to do the visits, to start supervised visits again. I believe that when we were here last, part of the guardian ad litem's recommendation was suggesting the psychosexual evaluation. This wasn't a motion, that was a formal motion brought by Ms. Teethers. And that was specifically because to find out whether there is an issue or not. And then the court recommended the evaluation to be done, and that was done, and we have the information as to going forward. And certainly if Ms. Rosen wants to put something in a report or makes a further suggestion on how things should go, but this was my client's original motion regarding the visits and a restraining order. I don't believe that Ms. Teethers had a motion, and the psychosexual came up at the hearing we were here last, just as a suggestion by the guardian ad litem. And I believe Ms. Teethers and Ms. McLain just kind of ran with it and is now making this the primary issue. And so my understanding just originally was this court said to Ms. McLain, do you have any more questions of the GAL? And now we're getting into formal argument, trying to force this issue of the psychosexual evaluation. And I think it's really an attempt to delay the moving forward of the reunification as suggested by Ms. Rosen.
I note that. I did ask if there was any further questions. I understand. I don't know if you were trying to get to a question, and if sounds like Ms. Day, Ms. McLain may want to know if your recommendation is to go with Ms. Rosen's recommendation or to stick with your initial no contact because things are still moving forward in the criminal.
So my recommendation today is to move forward with Ms. Rosen's suggestion on how to move forward. The criminal matter is dormant. There is no activity or action happening there. I've spoken with the detective and I followed up with them. There is no CJAC scheduled. And I know Ms. McLain said when we were last here that the child was going to restart with Ms. Anderson. And I don't know for sure if that's happened, but the specific sexual assault counseling was done. That was completed. And the allegations that were disclosures that were made are the same disclosures that have been being made. They're not new ones because there's been no new contact. These are the same disclosures that came all about at the same time. And if the court has had an opportunity to review my report in the sexual assault protection order that was original, there were some concerns there. My recommendation for the psychosexual evaluation was to help answer that question. Did this happen or did it not? And that's kind of where I think that this whole case rests. Ms. Rosen has given us an opportunity to have a very structured setting where this child can be reunited with their father, and we will have an opportunity to evaluate that contact, how that child responds, what she says to her personal counselor, how she responds in the visits, as well as moving forward. I don't have any objection to doing the psychosexual evaluation. It is very costly, and I understand that. I don't know whether the court wants to consider that or not consider that. I had a different recollection of what happened in court, so I still think that that's not a bad idea. I think that that's a way of answering the question, but I think that we still need to move forward. I think there has to be some contact. In the original sexual assault protection order, I had recommended supervised visits, and then there was a second criminal investigation started and allegations made for that second disclosure, second or third disclosure, whichever one that was. They were all the same type of information. So I did recommend that at the time. I do think it's safe to move forward. I think it's a very structured setting, and I think it can help answer some of those questions.
Thank you. I guess any other questions for Ms. Day from either counsel?
No, Your Honor.
No, I don't have any other questions. I would note that Ms. Rosen's report talks about or asks the court for recommendations on payment of their fees. I think the indication was that they had incurred 3 hours. I don't know, maybe Ms. Day knows. I don't know what their hourly rate is, and that wasn't disclosed in the report that I had received. So I don't know what 3 hours means. or what the anticipated costs are for this moving forward. So
I'm not aware of the hourly fee. I do know that what Ms. Rosen had indicated is generally those costs are dedicated by the court in a specific manner, meaning they're split 50-50 or 60-40 in some fashion, depending on what's happening in the family court. I don't know the hourly rate, but I can certainly get that information and share that with the parties right away.
okay.
I think the party's proportional share generally is close to 50-50 or 55-45, something to that effect. So we would just ask that they be shared equally, the costs.
And I guess our position would be that we're here because of Mr. Brown's behavior. And it's Mr. Brown who has put us in a position of having to be in therapeutic counseling and the potential for supervised visitation. He should bear that cost, particularly in light of the fact that he is not current in child support.
And Your Honor, all of those allegations have been unfounded by CJAC, by 2 CPS investigations, and nothing in the criminal investigation. And so at this point, I would ask that it be 50-50. If down the road something changes or the result of this is because it's Mr. Brown's fault or it's because of Ms. Teeler making this stuff up or coaching this child, then we can readdress that at final orders. But at this point, I think it's 50-50. The cost should not be an impediment to having this move forward. I think that's what's trying to happen here. My client certainly doesn't have the money. He's a teacher for children of special needs, and that shouldn't be a factor in preventing him from being able to have reunification with his daughter. And so we would ask that it just be shared equally at this point, and there can be a reservation for final determination at the end of the day.
Okay, so here's to get this issue out of the way. At this point, I'm going to still reserve on any psychosexual evaluation. I think that's something that Ms. Anderson and Ms. Rosen, if they see something, if they hear something, or if they're concerned about something, I'm assuming they would let the court know, and that can be readdressed at any point in time if they have a suggestion. Frankly, for any of the parties to get any, seek out any additional information. I'd want to hear that. That doesn't mean I'm ordering it, but I'd want to hear that. I think we need to be relatively transparent in this process. These are pretty significant allegations. And frankly, with a child this young, I don't fault anyone for reacting strongly to these situations, but we also have to be a little bit measured here. So I do think in reviewing the plan, I think Ms. Anderson is and please correct me if I'm wrong, but Ms. Anderson was the counselor that was appointed as part of the CJAC process, correct? So
Yes,
she's been working with the child and is going to continue to be a support, kind of a separate and distinct from what Ms. Rosen's going to do as part of any reunification. That does seem to be a very safe space. Ms. Rosen's been doing work in this community for an extended period of time. I've referred my own clients to her when I was an attorney. I have no reason to doubt that she would keep the child as safe as possible and frankly stop anything that would potentially be harmful to this child's best interest. So I think her plan does seem appropriate. It does appear to, she's already met with both parties and the child. It seems, well, maybe she hasn't met with the child, but Ms. Anderson obviously has. Right. She's met with both parents and reviewed all the paperwork. And given her experience, it seems like a very thorough and safe approach. So I will adopt that with the caveat that at any point in time, if either Ms. Anderson or Ms. Rosen feel that this is no longer in the best interest of the child, they'd be allowed to say that, and a motion is brought immediately before the court by, frankly, any of the parties. So whether that be Ms. Day, Ms. McLain, Ms. Poplawski, which with whatever the concern is.
So typically, in my experience on reunification, if they historically, in cases that I've had, if the evaluator determines that it's not going well, they will stop and ask the court for more guidance. Is that still in line with what you just
That's fine.
indicated?
Yes,
Okay.
I'd rather there be a stop and then have to come to court to move forward than I think, frankly, I think everybody sitting here that is dealing with this case, the last thing they want is for any additional trauma, harm to come to this little child. So the safest approach, and I defer to the counselors that are going to be working with the family and the child.
Your Honor, can you just speak to giving a time frame of when the initial 2 to 3 visits, 2 to 3 sessions with the child prior to the visits need to happen by? Last thing I want to see is this being put out like 2 months for those 2 to 3 visits. I think the guardian ad litem may have made a recommendation that should happen fairly quickly before the end of the month. So then the actual visits can probably start at the beginning of November. I think that should give it time.
I would agree that it should happen as quickly as possible. Obviously, I don't want to, and by saying that, I don't mean that the child has to have 3 sessions in 1 week just to push it through. I think, as long as it's reasonable and kind of in line with the counseling that she's been receiving with Miss Anderson, to get those started so the reunification portion can get started. And frankly, if there's any concerns that Miss Anderson has in those 2 to 3 sessions, that maybe we need 4 sessions, that we get it started so the reunification portion hopefully isn't pushed back. But I don't want it to necessarily be child-led, but I want it to be counselor-led, because I think we need to be very cautious. But I would agree with Ms. Poplawski. I don't want this, I don't want those 3 sessions to take the remainder of the year. I think we need to kind of, I don't know if they're seeing each other once a week, if they're seeing each other every 10 days. I don't know how often. I'm not suggesting that we completely expedite that, but I think those need to be set up and regularly kept so we can move forward.
So, Your Honor, I'd like to ask a clarifying question just for my own, and so that I understand how to help move forward. Miss Anderson is the therapist the child saw through the CJAC sexual assault program. The child regularly sees Celia Delaney at the tribe, and then she would begin these therapeutic visits with Miss Rosen. And I guess my concern is that we have a lot of cooks in the kitchen, and like a little direction on how you would like that to be handled.
Sorry, I think I've been referring to Miss Anderson as her regular counselor instead of Miss Delaney, and I apologize. So,
but just so the court is aware, Ms. Anderson
was the CJAC.
But she's still seeing her privately now. That's my understanding. I'm assuming.
Oh.
So that was not my understanding. So maybe we need to find that out.
So perhaps I could, if the court will allow Ms. Teeters to come on with her video and explain. My understanding was that once the sexual assault grant was up, that Ms. Anderson had rolled her into a private counseling patient.
Yes,
Is that correct?
yes, that is correct.
And how often does she see Ms. Anderson?
Every 2 weeks.
Yeah. And
So
she's
she's still
doing
seeing
that.
Celia Delaney as well?
That's correct.
So, Your Honor, I would just ask that it be Ms. Anderson. I think she might be in a better position than, since she did the CJAC, she's familiar with these sort of processes, and as reunification goes, that might be a better situation. I know that my client also had raised a concern. I believe that Ms. Delaney is the same counselor for Ms. Teeters. I could be wrong, but
That is incorrect.
She's not. That's incorrect.
okay. So I know that there was a counselor that she was seeing as well as that the child was seeing. I just want to make sure that if we can get a little more removed from that, that make a little bit more sense.
They do not see the same counselor.
Okay. mom and child. Here's-
Mom and child do not see the same counselor.
I think
We
Miss,
submitted a report for mother previously. I don't remember her name, but
I think, I'm gonna side with Miss Poplawski on this, not that, Miss McLean necessarily disagreed, but Miss Anderson, and I believe Miss Anderson has a working relationship with Miss Rosen, so, I guess, given her, perspective and frankly, she's directly on point to why we're in the situation as far as like the information, so, I guess, we'll keep her as the kind of point person for those 2 to 3 sessions. And then as soon as she's cleared, then we start the sessions with Miss Rosen.
Okay,
and
then-
the expectation though is that she would continue her private counseling so that the child has a backdrop, an advocate for her through this process.
Miss, and if Miss Delaney, I don't have it, yeah, I would never say a child can't see.
Oh, no, I meant Ms. Anderson, that Ms.
All right.
Anderson would continue.
Yes, sure. Yes,
Okay,
yes.
And I think that makes good sense, but I don't want it to be additional counselors as well. I think Miss Delaney's done a great job. I have no fault with Miss Delaney, and I don't, but if it's going to be Miss Anderson as the point person, I'd like it to transition be that, so that we don't have all this different input coming in. It just gets very confusing and conflicting for this child.
No, I would agree. And that's not to say that she can't see Miss Delaney, but I think as far as what we're trying to do is concerned, Miss Anderson will be our point person, and we'll go that route. And I did review the financials. I think we're at 5347.
Mhm.
With Mr. 53 and, I shouldn't say Mr. with the respondent at, 53 and petitioner at 47. In this situation, taking into consideration a few different things, I'm gonna, set it at, 40% petitioner, 60% respondent. And then
and that's
basically additional fees or concerns or issues that may arise that may impact those fees can be reserved for a final orders and trial.
so this is specifically related to the reunification counseling
Correct.
and
Miss Anderson and
the
Miss-
child's counseling with Ms. Anderson. Okay.
So that's 60% father, 40% for mother. Did I understand that correctly?
correct. And then that takes us to the restraining order. I believe that's the other issue, the only other issue that was on today.
Yes.
And I thank you for your memorandum of authorities. Both parties did some, sorry about the hammering next door here. We're in a state of flux here. So I don't know if you can hear that, but I apologize.
I can.
If you can. Okay, good.
Your Honor, on the restraining order, I would object to the late filing of the declaration on behalf of Teresa. I think that's how you say her name, Teresa Murphy. My client has had no opportunity to respond to that under the court rules. It exceeds the reply page lengths when you consider Mr. Brown's declaration as well as Ms. Murphy's declaration. And Ms. Murphy's declaration is based solely on hearsay. So I'm asking that the court not consider that declaration.
I would just ask then that this be moved over. I think that this is an important part of this situation. It was brought up that there was no information to provide where Mr. Brown is getting the information from, who's disclosing this, how this came about. We finally were able to have this person step forward, even though they felt uncomfortable about this, and fear of retaliation, to provide the declaration. It's also in reference to and part of our memorandum. If Ms. Teethers feels she needs to have some sort of response to that declaration, then I'd ask to move this over. But this is the first time hearing that this is being requested to be stricken. And so I think that it's an important part. I think the court has already reviewed all the documentation, has reviewed the memorandum, and the memorandum also incorporates a discussion of that in the case law that's been provided.
And again, the declaration is based solely on hearsay. It's not first person. I mean, the declaration herself says that she was talked to by another unidentified person at the Longview School District in the district office.
I think that the declarant, Your Honor, can talk about what has been happening to her and why she approached Mr. Brown and why she had concerns and what type of information she was concerned about and what she had to do with that information. And it goes directly to why my client is concerned for the safety of his job and why he's asked for restraints to be provided. And as the court is aware by the brief, and without going into complete detail, because I know the court has already read it ad nauseum, both briefings, this court can make decisions relative to any sort of restraints, whether they're full-on restraining orders, whether restraints within this family law action that are tailored to prevent any sort of a situation arising that my client's job is in jeopardy, that information is being spread or discussed or talked about, even if it's something that says these court proceedings are not going to be discussed with anyone, they're not going to be talked, and there is going to be reference to other outside individuals that don't need to be, other than the government agencies or other than the police or other than CPS. And so this court can obviously make those decisions. And my client also has stated himself about the fear for his job and what's been referenced to him relative to things being said that would come from nowhere other than these court proceedings.
So in counsel speaking in response to my objection, there is absolutely no argument that there is an exception to the hearsay rule as outlined in that declaration. And what she's asking this court to do is to take face value the factual statements that are outlined in there that are from another unidentified third party, which is clear hearsay upon hearsay. There's been no argument for an object or for that would allow the admission of this hearsay evidence, and we're asking that the court not consider it.
So, and I'm assuming you're objecting to a continuance at this point?
Well, I mean, if the I don't think that we need a continuance if the court's not going to consider it. If the court's going to consider it, then I guess my objection would be as to the fact that this has come in so late that we should be entitled to some fees.
Your Honor, I would also ask that the court inquire into the guardian ad litem on her investigation. I think the guardian ad litem has some information relative to what her understanding is happening as well regarding these proceedings and things being said. I mean, this is pretty significant when the whole issue with this.
Okay, hold on. Here's the thing. I don't see this declaration as putting those words coming out of Ms. Teeter's mouth. So I would agree with Ms. McLain that it's hearsay that doesn't get us any closer to, the goal line than the initial allegations. I don't know. I mean, I guess if Ms. Day has specific knowledge about Ms. Teeter's specifically herself making accusations and spreading those around, I'm assuming Ms. McLain would want to know that as well and would want to know about it before Ms. Day just says it here in open court. I guess so. Very carefully, Ms. Day, I'm going to ask if you have any firsthand information about the concerns, and I'm assuming you understand the restraining order request that was made by Mr. Brown. If you have any firsthand information that would be beneficial for Ms. McLain and Ms. Poplawski to know before we move forward on this issue.
I don't have any firsthand information about that. I have done some investigation on that as it relates to other issues, and that was some of the discussion in that. So I don't have anything firsthand. My only input about this that I would share is that it's from my position to the court is to remember this is a very young child, And this is information, if it is being shared, that could impact her later on down the road. And that's my only concern about this so far. If I come across direct information like that, I would make sure both attorneys knew that right away, whether we were coming to court or not.
Based on that, Ms. McLean, I don't know, do you want any opportunity to speak further with Ms. Day about that topic?
No,
Okay.
I would just ask if Ms. Day spoke with Holly Budge directly.
Yes, I did.
I would just ask to explain what the conversation was.
well, Your Honor, I guess at this point, again, we're talking about constitutional ramifications as it relates to restraining my client's free speech. This is not trial by ambush or a motion by ambush. My client's entitled under the local rules to have all of the evidence set forth supporting the motion to allow her a competent opportunity to respond to the motion and the factual allegations that are being lodged against her. If counsel has talked to Ms. Budge, then Ms. Budge could have submitted a declaration, but they made the tactical decision not to do that. And an effort to try and obtain information third hand through Ms. Day's guardian ad litem investigation is simply inappropriate at this juncture. Ms. Day has not issued a report that my client has had an opportunity to review or respond to. And I just see this as red herrings all over the place, to be quite honest.
Your Honor, we're just asking to protect not just my client,
I
but also
understand what you're wanting to do. So here's where I'm at. I'm a little bit torn on this decision. I think that I understand the case law that was provided by both parties. I understand that an order could be crafted to very specifically prohibit free speech, what would otherwise be considered free speech, based on certain concerns and findings. I mean, we all know that we have a right to free speech. We also know we can't yell fire in a theater. There are a lot of concerns in this case. However, we're unfortunately in a situation right now where anybody at the Longview School District, anybody at the Kelso School District could be watching what's happening right now. We don't know, I don't have anything that says it's Ms. Teeters that's saying these things. So at this point, I'm leaning towards the denying the request for the restraining order. I understand Mr. Brown's position. I frankly think Ms. Teeters would be foolish to speak about this outside of official investigations. Speaking from my criminal background, speaking from just my position, my hope is that she isn't do that. I do agree with Ms. Day that it would be, I think the more information that is out there in the general public, the more detrimental it is to this child as the child grows. So I would greatly hope that she's not doing this. I clearly don't, if Mr. Brown loses his job and these are unfounded, which so far they are unfounded, and continue to be unfounded, then that doesn't help anybody in this situation. So I'm concerned in general. But I'm also concerned because it sounds as though the respondent believes that they have more information that hasn't been presented to the court. So and I don't know Ms. Murphy's declaration. I did review it. Frankly, I was kind of with Ms. McLain on this. It didn't really enlighten me too much because it basically sounded like, coffee room gossip. It didn't indicate that it was Ms. Teeters that was the origin of these rumors or allegations. So, but I'm also concerned because if there's, I guess, Ms. Poplawski, do you believe that there's more information that could be provided to the court that directly ties Ms. Teeters to these statements?
I think the concern is, and I think it's touched about a little bit, Ms. Murphy, is the fear of retaliation for people to be signing their name to something. And so with the guardian ad litem having spoken to individuals as part of an investigation, bringing information that only really only would be coming from these proceedings and the knowledge, intimate knowledge of what's been going on with the CPS, with the police investigation and those sorts of things. And my client is simply just trying to get some restraints to stop it, just to stop this before it damages his reputation in his profession, in the community, and just snowballs and spirals out of control. And I think part of even the memorandum was saying the stuff can be narrowly tailored. I mean, and often we see where it says neither party is going to be discussing these proceedings unless it's part of an active investigation, that they're not going to be doing this with third parties. I think that in and of itself could help put a halt to some of this. I think that there's a fear for a lot of people to come forward. They have their jobs as well. And then they're saying information, putting their name to in a court file. Now they feel they're at risk. And that was pretty obvious from Ms. Murphy's declaration. So yes, I think that there are people, but it's extremely difficult to be getting people to come forward relative to this.
So I think the short answer to Your Honor's question is that no, she doesn't have any factual evidence that suggests that my client is engaging in behavior that they're trying to tag her with. Again, as you indicated, and I think I argued this at the last hearing, this is currently being watched by who knows, and who knows how many people. So that is I'm sorry.
57 people are watching right now.
I'm sorry.
57 people are currently watching this hearing.
Okay.
So
I don't have access
who those
to
folks
that.
are, I don't know.
So yeah, I don't know who they are. They could be counsel. I mean, counsel and I believe to some extent Ms. Day have openly talked about the CPS investigations, the allegations, the information that is part of this. But there has been nothing to suggest, and my client has submitted a declaration to you that outlined all of the legitimate people that she has talked to relative to this, which includes the child's school and daycare providers, in order to affect the original sexual assault protection order and now the restraining order that are currently in place, so that those can be lawfully enforced if they need to be. There isn't one shred of evidence that my client has done anything to harass, molest, disturb Mr. Brown's peace. She is a mother who's trying to protect her child.
Ms. Poplawski, anything else?
No, Your Honor, my client is just trying to protect his job and his reputation. And again, allegations that have been unfounded by every single independent professional person who has taken a look at this. And it just isn't stopping for him.
Okay, there were a few things that were submitted that I kind of made mental note of that I think do really hold weight to how I'm going to rule in this case. And I think one of the things is we have the Kelso superintendent that is aware of the allegations, has made an unfounded finding of anything that's going to directly relate to Mr. Brown's position. Mr. Brown, obviously, I don't know that is I guess a letter that indicates, hey, you're always going to have a job here. So, and I understand his position there. But it clearly is something that there's no new allegations. The allegations are out there and you still have a job. So there's that. Additionally, in one of Mr. Brown's declarations, he indicated that this isn't the first time that it has happened, that he's already had to go through and address this before in the same job that he's in now. So, and that those were unfounded and that there were no issues there. So this is, if I take those two statements from Mr. Brown, isn't the first time this has happened. Everybody knows about each time this has happened, and they've both been considered unfounded by my job. Clearly, does that mean if a parent that's currently got a child that he interacts with, or someone gets information about this, that couldn't have raised concern in that individual, and then they move forward and do something? No, it doesn't mean that, but it also means that the school's made a determination at this point, where they're at with these allegations. And I think we all are aware, at least at the time, where we are with these allegations. We do have a parenting plan that's in place, and it indicates, at least under the section 14, communication with the child, that neither parent shall advise the child of the status of the child support, legal matters, anything regarding the relationship, share, or allow the child to access any part of the GAL report, different declarations, use the child directly to gather information about the other parent, or take verbal messages to the other parent, make derogatory comments about the other parent, or allow anyone else to do the same in the child's presence. Neither parent shall allow or encourage the child to make derogatory comments about the other parent. What I'd like to do is enter maybe an additional order or an amendment to the parenting plan, that the parents will not discuss these allegations outside of official investigations through any authorized parties, whether that be DCYF, law enforcement, their own employers, or the counselors that are dealing with these allegations and they're moving forward with. So I'd like that to be part of the parenting plan and not as a restraining order. I think we're in a position now where, Ms. Day said it best, we are where we are, but we need to move forward. Rehashing this, and again, I'm not claiming that, I'm not taking sides as far as it's happened or it hasn't happened. I think we need to move forward and consider the best interest of the child, and ongoing rumors about certain allegations aren't going to be in the best interest of that child. This is a school-age child. This is a public hearing. These are public records. They're accessible to pretty much anyone who wants them. So we have to be very considerate, I think, of that. So I would assume that might fit best in section 16, just kind of as an addendum that moving forward.
You mean in section 14?
We can do it in 14 as long as it's not under the communication with the child. But yeah, 14 works.
Okay. And have you already put together language?
No.
Oh, okay.
I can.
Would Your Honor please put together what language you deem to be constitutionally appropriate, even though it's not a restraining order, but that you would like to have included? And then I think I did the last parenting plan. I can just plug that in as an amended parenting plan and submit that to counsel and Ms. Day for signature.
That would be fine, Your Honor. I think otherwise counsel and I will end up disagreeing. So I think if the court just kind of issues some language, that would be the best.
I will, how about I just do a bench order, adding essentially another section for 14 to the parenting plan, temporary parenting plan. And then I will scan it and email it and file it, and I'll include you, Miss Day, as well.
Your Honor, do you want me to can you just include in that order that number 162 will be put under seal, or do you want an absolute, completely separate order, or would that be appropriate just to put it in that same order since you're going to be issuing a separate bench order?
I think we're going to need to have another order no matter what, because the court's reserved as it relates to the psychosex eval. You've provided specific parameters as it relates to the reunification counseling. So I think we're going to need to follow up with an order in general.
That's fine.
When are you looking at potential presentation date, Your Honor? Did you indicate the next one available is the 31st?
Yes, unless we want to do a Friday at 8:45.
The
You're not-
31st.
I'm not available on the 31st, and I would also just ask that that this not be a delay to get the counseling sessions started. What I could see is by the time we get the presentment, then we're going to start working on getting the child into these sessions, and it really is going to take to the end of the year. So I just want to make sure that the presentment date doesn't create a longer delay.
I would hope that wouldn't,
I don't see that, yeah.
I would hope that wouldn't. So I would ask the parties to move forward on those scheduled meetings. And I'm assuming Ms. Day, that Ms. Teeters and Mr. Brown received a copy of that recommendation letter from Ms. Rosen. Okay. So
Yes,
I
and
would-
when
I'd
I
ask
reached out to everybody, I'll send that information out so that everybody knows how to move forward.
So yeah, I appreciate this, that Ms. Poplawski. I would ask that start now and not start at the entry of the orders. If you're not here on the 31st, let me see here. I have Friday the 20th, Friday the 3rd, or we can go all the way to October 7th, or excuse me, November 7th.
I think November 7 would work much better for me if council works for you.
That's fine. November 7 at 1 o'clock, Your Honor.
Yes.
Your Honor, I would ask to be excused from that presentation. I have trials back to back for the last 2 weeks and the first 2 weeks of November, so I will sign off.
And do we want to set it to review progress, or do we want to just have that noted up if there's any concerns with that?
I would just assume we note it up, just because we don't know what their timeline is going to be as far as how the child responds to that process. And I'm assuming that Ms. Day and at least Ms. Day will keep us updated on any contacts that she receives. So
Yes, ma'am.
thank you.
Your Honor.
I anticipate, I just need to get a bench order, and then I'll fill that out. I will scan it to you. So I'm going to scan it to you before it's filed, just so you know,
Okay.
it won't be have the stamps and everything on it. But I just want you to know what the language is right away. It's going to be along the lines of: the parties shall not discuss the allegations of their child in common with anyone outside of official investigators, and I'll list law enforcement, DCYF, the counselors, and their counselors until further order of the court.
So do you mean specifically with regards to the allegations? Because I mean, that language in and of itself would mean that my client wouldn't be able to talk to the grandmother about her granddaughter.
I'm assuming she's already told her what the allegations are. Why does she need to continue having conversations specifically about the allegations? She can talk
You didn't
about
say
her
that. You didn't
counseling
say
update.
that. No. You said that nobody was allowed to talk about the child to anybody.
No, the allegations of the child in common.
Okay.
The allegations that were made. I'm assuming
Sure.
that family members are already aware of what we're dealing with. That cat's out of the bag there, but further discussion of that. That doesn't mean that, hey, child's doing super great in their counseling with Miss Anderson. I don't think anybody has a problem with that, but
Yeah.
we don't need to rehash the allegations with anyone outside of any official investigators. And I'll list those and the counselors. So,
Okay.
and I'll make sure to include, if Mr. Brown has a private counselor, obviously he can discuss what he wants to with his private counselor. Ms. Teeters with her private counselor, they would be included in any discussions, but
And I'm assuming the guardian ad litem and our
The
respective
yeah.
attorneys and, okay.
Your
Okay.
Honor, I'm not sure, but there isn't a restraining order. I just want to make sure by this process for the visitation, my client isn't violating the restraining order. So some sort of language that we can do, or do we have to amend that separately that, this is modified to the extent regarding the reunification visitation or something? I just don't want to have an issue with my client relative to that.
Is there a copy of that filed in this cause number? Do you know, Ms. McLean, or is do you have
Yes,
other cause number?
there is a restraining order in this case. It is the temporary restraining order was filed on May 23. It's clerk's paper number 36.
Thank you.
You're welcome.
I thank you for raising that, Ms. Poplawski. I highly doubt, I guess, that anyone would, his participation in this court-ordered reunification, hopefully that wouldn't result in a contempt motion or something of that nature, but I don't know if, let's see, this specifically says,
I don't see that engaging in therapeutic counseling would be a violation of that because it's not the child's school or daycare or my client's home, vehicle, workplace, or school.
If it says, I don't have it directly in front of me, but if it says no contact, then I just
It does not. The temporary parenting plan is the one that provides for no contact.
temporary restraining orders do not disturb the protected person or child, do not go into the grounds of that protected person's home, workplace, vehicle, school, or daycare of the child, and not knowingly stay within 500 feet of the home, vehicle, workplace, school, or daycare of the child. So,
And not to assault, harass, stalk, molest.
right. And then the parenting plan temporary under 4A does indicate no contact to be reviewed after conclusion of investigation. So what I'll do is I'll include in the order amending kind of an addendum to the temporary parenting plan that contact with the child is allowed based on the court's ruling on October 10th, 2023, and the suggestion of reunification therapy as outlined by Charlotte Rosen, and I'll just refer to her letter. So so that's clear as well.
That contact with the child is allowed through the reunification therapy.
Yes.
Okay.
So I'll do those, Ms. Poplawski, both in one bench order as an addendum to the temporary parenting plan. So
Thank
that hopefully should insulate Mr. Brown from any concerns there.
Is the court, so the court's denied the restraining order. My client has made a request for attorney's fees as well as the immunity request under RCW, what is it, 4 something?
And Your Honor, I think we already addressed the immunity section in our briefing, and that I don't believe that she's met her burden relative to that, because my client never indicated that any of the requests were relative to information provided to the police, to CPS, or in that respect at all. I think it was relative to things that were happening within his job. So I don't think that falls under the immunity provision. And so we would ask that you deny the fees.
I did review everything with relation to that. I did, and I appreciate again that both parties did provide some case law regarding the request for fees. Frankly, this is a situation where I think both parties reacted strongly to the allegations in different ways. I'm not gonna make a finding that the $10,000 fee is appropriate in this case, so I'll deny that request. There was a request for an attorney's fees from Ms. McLean as well, and I think it was 1,500 that you were requesting.
The original request was for 1,500 on the ex parte, and then with the memorandum and everything, my second order that I submitted asked for 2,500.
Okay. And
You know, I don't believe Ms. McLean was in the she didn't expend any time in ex parte.
When we were here for what I meant, when we were here for the first hearing on the ex parte order, which was what, 2 weeks ago? 3 weeks ago?
And I believe, Your Honor, we said everything over. We were here relative to my client's motion for temporary orders as well. So that was part of the hearing, which she had to be at anyway. And so everything was then reset because the court wanted more information regarding the reunification counselors. So it wasn't any additional time or any additional effort at that part.
at this point, I'm not gonna award any attorney's fees either. I think this is a bit of a quagmire, and I appreciate both parties' positions, but I'm not gonna award any attorney's fees at this point.
All right, thank you.
All right, good luck, everyone. Thank you. Ms. Cutter, do we have anything else? I'm not showing anything else.
No, that completes the docket.
Wonderful. We can go off the record.